Welcome, everyone. This is our final plenary session entitled Taking Stock, and we have 4 wonderful panelists to help us with that exercise. They are familiar to all of you. They've been speaking and chairing in various sessions. I'll just briefly introduce them. We have Dame Rosalyn Higgins, former President and Judge of the International Court of Justice. We have Sarah Cleveland, Professor of Human and Constitutional Rights at Columbia Law School and the US nominee for Judge of the International Court of Justice. Miguel de Serpa Soares, Undersecretary General for Legal Affairs and UN Legal Counsel, and Professor Dapo Akande, Professor of Public International Law at the University of Oxford and incoming member of the UN International Law Commission. So the format of this session is that I will ask our panelists some questions linked to the overarching themes coming out of this conference. Then we'll turn to questions from the audience, which I have already seen coming through on the app, and also from questions live here in the hall. But first, just a preliminary remark on continuity and change. By speaking of times of emergency, the conference title, which has been much commented upon in each panel, suggests that we are in a moment that is exceptional. But it's also been acknowledged in nearly every panel that international crises are nothing new, and that people have been writing about international law in a time of crisis for a century. That we are merely at a point on a continuum. One view coming through, an example is Sir Christopher Greenwood, citing Judge Crawford, is that we have to use the international law that we've got. It cannot necessarily solve crises, but it can provide a means for their solution. Another view coming through in the panels is that current events call for disruption. Something fundamental has changed on an existential level. We need new norms, revitalized institutions, alternative centers of power, children bringing cases against 33 sovereign states. As the climate change panel yesterday said, if we use conventional methods that take 17 years, we'll be left with nothing to save. From another angle, Christine Chinkin yesterday urged us to look behind what we mean by this word crisis, to question the role of elites, to question our own mindset. Jean d'Aspremont told us this morning that international law lives off crisis, international law thrives on crisis, and he wasn't saying that necessarily in a positive way. Christine referred to what Hilary Charlesworth wrote 20 years ago in her article, A Discipline of Crisis, and I think it's worth quoting. International lawyers revel in a good crisis. A crisis provides a focus for the development of the discipline, and it also allows international lawyers the sense that their work is of immediate, intense relevance. But, she argues, this shackles international law to a static and unproductive rhetoric. Through regarding crises as its bread and butter and the engine of progressive development, international law simply becomes a source of justification for the status quo. The framework of crisis condemns international lawyers to a sort of disciplinary hamster wheel. So if we are to get off this hamster wheel, if we agree we're even on it in the first place, where do we find these new tools and solutions? How do we trigger them? And what are the roles of institutions, governments, policymakers, civil society, judges, lawyers, scholars, and students? And with that, I turn to our first question, which I'm going to direct to all our panelists, which is the international system as a whole and as it presently stands adequately equipped to address emergencies? Maybe we start at that end with Sarah.
Thank you, and thank you to the organizers for including me in this fascinating discussion. I'm happy that it has been reconvened since 2019. Good to see everyone. I wanted to start by reminding everyone of the well-known in America quote by Louis Henkin, perhaps less well-known here, that almost all nations obey almost all principles of international law and almost all of their obligations almost all of the time, which captures, I think, an important part of the picture that is not where the lens has been in this program, but I think is a very, very essential part of the story of international law, which is that international law happens all the time on a daily basis, not in crisis. And it may be the crises that test international law, and it's also the crises that end up in case books that we teach. But part of international law is designed to prevent crisis. And of course, this is a point that Christine Schinken made yesterday, among others. The second point I wanted to make is that international law, the whole system, is not really a system. It's a very disaggregated regime of different bodies of international rules that are designed to address different topics and different types of institutions that have more or less capacity to oversee the implementation and compliance with those rules. And so the challenge for emergencies, like the challenge for other aspects of international law, is to map out on that very patchwork regime the places where the international legal system can respond, and properly so. So yes, in an emergency, we need to use every tool in the toolbox. We need to think beyond major international and regional courts and think about mechanisms like those on the Human Rights Council that can respond quickly and agilely, regimes like or bodies like the Venice Commission, which I sat on for a number of years, to help fill in the gaps that may exist with compliance. And I guess my final point in this regard is that I've written a good bit about the need for greater connectivity among the regimes of the human rights system, and I think the same could be said with respect to the international law system in grappling with emergencies, which is we need to better develop the connectivity between different courts, different tribunals, actions of states, actions of regional political bodies, to help better build a systemic response in times of global emergencies than the international law system was really designed to do. And I would say that that's probably the place where there's not only a consent gap, as Sam Wordsworth said yesterday, but also an institutional capacity gap as well.
Rosalyn?
So answering the question, trying to answer the question of whether the international system as a whole, as it presently stands, is it adequately equipped to address emergencies? The answer to me is manifestly no. But also, I think this is nothing new. The landscape of crisis or emergency has changed. The landscape's changed. Everything is happening simultaneously, and we're feeling it particularly in Europe. But the underlying answer to whether the international system is adequately equipped to address these problems is no. Today, it's just all the problems are writ large, are happening together. So we have climate change, we have the awful events, which it's amazing how quickly one pushes them into the background, but the terrible events of the last few years in Syria, and one can go on listing them, as well, of course, as the Russian military action in Ukraine. It's probably not the international legal system that is the cause of it not being adequate to address emergencies. I'm afraid we're immediately back into the politics. To me, it seems it's a combination of various things, a combination of the veto, even to protect not oneself but others, which has been allowed to slide into that over the years, the fact of major economic power and the feeling not just that it's dominant, but that one daren't put oneself on the wrong end of that one needs it. And of course, the existence of nuclear weapons. The combination of these things, it seems to me, is the reason why the system isn't and won't be adequate. There have always been gaps within the system that need filling, and many of these have indeed been plugged. I definitely felt the generational gap when I talked earnestly as I arrived here about the years of the hijacking conventions and was looked at blankly by some of the Foreign Office colleagues. But I lived through the era where that was a major gap to make the system work better, and it's been largely plugged. The operational elaboration of universality, there have been strides made there. Bits, of course, and that, as was said in the excellent panel this morning, they were set up indeed at times of crisis. There's been a thickening of international humanitarian law and, of course, the development of international criminal law, which I think satisfies the sense of the need for justice, but I cannot for the moment see it as operating preventatively. So the legal counsel has spoken on the changing role of the Assembly vis-a-vis the Security Council. That will have, I'm sure, its own implications. I don't answering the questions that have been laid out under this big head. I don't have the sense that derogations are really a major problem for the system. I was struck by the comment made in a panel that exceptions are becoming normalized. That I thought was very insightful. But I think we really have so much to do. I'm not one of those international lawyers who thinks there are going to be big answers from our discipline. I'm one of those who thinks we do the little we can manage to do.
Miguel.
Yeah, thank you. I mean, it's a long question. There's so elements of a possible reply. You can write an essay after. So I wanted to pick on something that Sarah said and also then Rosalyn on something that you've said. And the first point that I find interesting, in my UN years, I never heard a state rejecting international law. Yeah. I never heard a state or other international actors say, I don't believe in international law, I don't care about international law. So every state in every situation tries to build some sort of legal construction to justify their actions. And the same has happened on the 24th February. There is a very long legal explanation justifying, according to Mr. Putin, the invasion of Ukraine. Of course, the factual premises of that analysis, most members of the international community reject, but still the attempt is there. Other element which I think is very important, and that was mentioned yesterday by Sir Christopher and now by you. I mean, lawyers, we can't capture everything. We are in a very specific geostrategic period where things are moving and we don't know exactly to where. And so we're perplexed and some of us anxious, and where are we going to? We don't know, and we will not find those answers alone as lawyers. But we have to, take account that the world has changed. The world in 1945 is not the same as today. I mean, there were 50 members in 1945 of the United Nations, the constellation of power is different, and we have new factors that we have to deal with. So when I see an article in the Chinese Yearbook of International Law, the title is "Human Rights are neither necessary nor universal," that's very perplexing to us. But we still have to think, how are we going to organize a dialogue with this part of the planet, which represents 1.7 billion inhabitants? And this is a very complex issue. Now, does the system work or doesn't work? It keeps working. And I'm going to bring back this discussion to the UN and to the UN Charter. And of course, I'm very protective of the Charter and of the system, not only because it pays my salary, but I really believe in the system. The first thing is, the Charter as a constitutional text has resisted for 76 years. It's a solid text. It was capable of adapting to many different situations. The Cold War, decolonization, it's still there. Maybe it could even be better used. Maybe it has more potential that member states have not used. The second point is that the idea of reform and that the system is not complete and needs to be reformed exists as long or as far as 1949. That's the first book I found in the UN library about UN reform, 1949. It's kind of early, right? And it's, you know, it's a constant term of this debate because it's not over, this process of building a multilateral system that achieves its main promises. And I think part of this discussion is because we are reasoning, and the question is a little bit also in that sense, it's too much focused on peace and security as the central focus of attention, quite rightly, because we all see in television images of the suffering in Syria, and then the normal cities or the global citizen ask, what is the purpose of the UN? Where, again, the UN, as I said before, is not the Security Council. There's much more going on. I do not think this reform process is over ever, because the society keeps changing. I don't think the lawyers will find all the replies to them. But there are the parts, again, as I try to explain, because we are all a little bit in an after-party mood, you know, after the... No, it's the 90s was this global optimism. You know, everything was possible. I mean, international criminal justice, but on the basis of it, it's a very creative interpretation of the Charter in order to allow for the creation of international ad hoc criminal tribunals by the Security Council. It's kind of creative when you think about it. We're not in the global optimism, which some authors have called obtuse optimism. We are in a different period, and we still can do things together. The system is imperfect. It will probably remain imperfect for a few centuries, but it still exists, and that's what we have, and we have to protect it as much as we can, because there's nothing else.
What would you name this period, if not the period of optimism?
The workaround period, the do whatever is possible period, but do.
Yeah.
Again,
Yeah.
you know?
We'll come back to that. But Dapo, your thoughts on whether we're adequately equipped in the international legal system?
Yes, I'll just focus on one area where I think international law is not adequately equipped to deal with emergencies. I think in many of the panels there has been a discussion around what constitutes an emergency, and people have their different definitions. But I think one of the things that is often thought to be at least a sign that it's a moment of emergency or a moment of crisis is when the institutions that we've set up to deal with problems collectively, when they are unable to deal with those problems. So I think that's, in many cases, a constitutive feature of an emergency. Then the question that arises is, if we can't have effective collective responses, how does the law deal with individual responses to emergencies? And so I'll just pick on this area in the law of state responsibility in particular. This whole question of to what extent, for example, can states acting individually respond to violations of obligations erga omnes, obligations owed to the international community. And also, to what extent can states, or to what extent do states have an obligation to cooperate to bring to an end serious violations of norms of use cogents? Because I think those are the scenarios where we think, okay, this is an emergency situation because of the kind of values that those obligations reflect. But we see that even just within international law, and for the moment, not even thinking about the political issues, even within international law, we still have no settled answers to those questions. How should states respond outside of these collective entities when you have these situations? And you see it a bit with what's going on now with Ukraine. To what extent can states take measures, essentially sanctions, which would otherwise be inconsistent with their obligations, but they are doing it because they are responding to these violations of norms that are owed to the international community? To what extent do states have an obligation to do that? Even within the law, we still have no agreement on what the law requires of states in those kinds of situations. And so for me, this is an area where I think we need to make progress, so that at least when the collective mechanisms don't work, we have some sense of what states should be doing individually. And the same is true, I think, in the International Criminal Justice Fair that we've been talking about. So we've spent the last 20 or 30 years trying to build up a system of international criminal justice with international tribunals. But at the same time, we also talk about the ability of domestic courts to exercise jurisdiction to respond to these atrocities. But again, we don't have agreement on issues of universal jurisdiction. We don't have agreement on questions of immunity. And again, these are issues of, okay, so if the ICC is not working, what can states actually do individually to respond? And I think we still have work to do on how states respond individually to emergencies.
Philippa, can I just add something to the comments of colleagues? So both the legal counsel and Professor Cleveland have touched on it. You said the UN is not just the Security Council. You talked about the ways in which international law works each day. What you said used to be how, and using Lou Henkin, because I'm almost of that generation, we used to use that as the response to something quite different, namely, does international law really exist? And now we're using those same arguments, very persuasive to me, to answer something else, which is talking about the efficacy of the system. But of course, reality and efficacy are closely related.
Yes. I want to now direct a question to the legal counsel and Professor Cleveland, following up on that. And this is picking up on your point that the UN Charter has more potential than we have been giving it credit for. Because during this conference, we've been hearing in panels about the fact we need a multi-regime, multi-level, multi-generational response to some of these crises, including climate change. And it shouldn't just be left to the UN, to the courts, to The Hague, to New York. And from your perspective as legal counsel, what are the prospects for such a multi-regime, multi-level, multi-generational response? What do you think the pros and cons would be?
I'm not sure, because I'm not sure I understand the question and all those terms. But I can tell you that in the new big policy document that is being prepared now in the United Nations called Our Common Agenda, which will be a little bit the big policies document of the Secretary General. So the discussion has started with member states. There is, as one of the objectives, to have a more, and these words are very complicated, particularly for non-English speaking citizens, multi-layered, multi-network, multilateralism, whatever you want. So this actually tries to reflect the idea of having a more inclusive system. And that means bringing more and different actors to the multilateral platform to participate in discussions of different legal instruments, for instance, because we are lawyers. An example, because this has to be translated into examples. So what is this about? How does it work? I think the only serious multilateral process that is taking place right now, and I'm sorry to come back to environment, but this is like the main focus of my attention, this new BBNJ treaty.
Yeah.
There is, since the beginning, the presence of civil society in the room, which is something that member states are very, very suspicious, and they really don't like to see civil society around when they are discussing. But even if you can reserve some segments for member states only, I have a very good impression of the openness of this multilateral process, because I think, and it's a very large platform of civil society, environmental organizations, and so on, because I think they have brought some value to the discussions. It's not a bunch of fanatic conservationists, so actually they brought something useful. They help us, the UN, maybe I shouldn't say this so openly, to put pressure on national governments. But the main part of your discussion is actually about internal politics, not as much about international politics. So how national governments and the political actors take account of the different voices around these problems. For instance, I suspect that environmental matters and climate change in particular is very, very, very important for youth.
Yes.
Okay? And I think it can be even a decisive factor in national elections. So here again, a lawyer talking about things he doesn't master. But you see, so the discussion starts at the national level. So how do you take account and you include all these voices and you meet the concerns of large segments of your population? Because if this starts at the national level, the international level will follow. I don't have any systemic distrust of civil society in the multilateral process. My experiences are actually quite positive so far. And so this is something we would like to continue to explore in the United Nations with the support of member states, because we can't do much without the support of member states.
Yeah. And Sarah, some of the points that the Legal Counsel's been raising, does this correspond to what you meant about building connectivity between regimes?
Yes, I mean, Miguel is talking in part about the increasing openness of the UN system to civil society and interests beyond states. And I think what I would say is that international law as currently practiced already is multi-level and multi-generational, that we have to be effective teachers of international law. We have to look beyond the UN, and we have to look beyond international courts, as important as they may be. So I would no more think that I was giving a full picture of the possibilities for accountability if I only taught the International Criminal Court, than if I only focused on the UN system and what's happening in the General Assembly and the Security Council. So what I have been focusing on is how to think about the various pockets of oversight and implementation and enforcement capacity that we have in the system, which are often very hermetically sealed from each other and tend not to talk to each other. I mean, Judge Iwasawa gave the example yesterday of a norm enunciated by the International Court of Justice being picked up by the ITLAS Tribunal. And that's just one example of the ways in which norms that are enunciated in one place can be transported and implemented somewhere else. And that may be through state actors, it may be through soft law mechanisms, it may be through the activity of civil society groups. And I think we've seen a lot of that in the current crisis. I mean, I think on a daily basis, I focus on what the international system is not accomplishing, but I'm also astonished by how much the world has come together and different regional systems have come together and creative approaches have been used to try to respond, whether it be climate change or the conflict in Ukraine. Or the pandemic. And I think we're just in the beginning of all of those stories.
And just to add an epilogue to the example you gave, drawing on Judge Iwasawa's point that something the ICJ said in an advisory proceeding was then applied by ITLOS in a contentious dispute. And the epilogue is it was then invoked in an English court as well, in a case brought by individuals. So despite the consensus, I think, that we need to look beyond courts, I want to bring us back to courts for just a moment with a question for Dame Rosalyn and Dapo. So one of the other themes coming out in the panels has been the value and the urgency of strategic litigation in certain areas. And there's been examples given from domestic courts, before treaty bodies, advisory proceedings on the horizon in the ICJ and ITLOS. And one of the discussions is, is it really about creative lawyering, innovation at the sort of party level that's then sort of not allowed to go too far by rigorous decision-making at the arbitral, judicial, or treaty body level? Is that where the balance is struck? Or is there still a role for creative judging? Would you like to start, Dapo?
Sure. It's sort of striking to think about where we are now with regard to the use of international courts and tribunals, or also with regard to the use of international law in domestic courts and tribunals. I tend to think about when I did my LLM, taught by Rosalyn Higgins, at the LSE, and my year of the LLM was 1993-94, so nearly 30 years ago, which is hard to think about. But I still remember that in that year, if you set aside the decisions of the European Court of Human Rights, if you left them to one side, you could actually say, I have read every decision of every international tribunal issued in this year. It was actually possible to say that. But to think about where we are now is it's a completely different world from where we are then. Now, I know this isn't necessarily answering your question, but it's related because the question is, has that on the whole been a positive thing and something that we should continue to then seek to use in particular ways? So the first answer, I think, is a fairly sort of obvious one, that if we are talking about using judicial mechanisms to clarify the rules of international law and to give further granularity what the rules are, that surely is, on the whole, a positive thing. Mm-hmm. And that's why we are, in a sense, where we are now, that people, states, individuals, companies just see value in that. And I think that's been a very positive thing. So if strategic litigation is directed in that sense of sort of clarifying the rules, providing granularity, I think that's a good thing. However, I think there are a couple of things that one needs to be careful of, both for those who are thinking about using courts, but also for whoever the decision makers are, judges, members of treaty bodies. And so the first thing is that, of course, when you have judicial decisions that seek to clarify the law in the international system, actually the law is not always very easy to change. And sometimes you can have an imbalance in the international system between a process of actually saying this is the law, and then if you don't like it, changing it. In a domestic system, if you don't like a judicial decision, maybe you get an act of parliament that says the law is different. And in the international system, it's not always that easy to change the law. We have had some notable cases, but the risk is that actually when you have litigation by which, in essence, really forces the court to take a position on particular issues, it might have the effect of fossilizing the law. So we saw in another panel earlier on the formation of international law, there was discussion of domestic courts being reluctant to take particular positions on customary international law because they say this is not our role. And so if you've got, for example, an international court that has reached a decision on something, it might make it more difficult for states or domestic courts or others to say something that is different. So that's the first risk. The second risk, which one has to be attentive to, is, I think you talked about, the possibility of hard cases making bad law. The second risk that one has to be attentive to is that international law, at least to my mind, will only be a sustainable project to the extent that it continues to be seen as universally applicable. And so the problem is that when if one gets to a position where you have decisions that are made in particular contexts because they are very difficult, and so the law moves in a particular direction, to make that sustainable and to make international effective, I think it's very hard to not then generalize that. It's very hard. Obviously, courts do their best, but it might be very difficult actually to have the consistency that I think will strengthen international law.
Yeah. Rosalyn?
Well, the use of courts in this proactive and imaginative way is, of course, very understandable. We have to remember, though, that international law is much, much, much more than pronouncements by courts. And going along with that, it's also the case that simply not every major issue is suitable for litigation. I mean, if you take the problems of the Middle East, you can, or even India, Pakistan, you can slice off particular aspects that can be usefully litigated or pronounced upon in opinions. But the problems as a whole, which are so large, go back so long in history, are not going to be resolved by courts. Now, I do see that strategic litigation could presumably help specific clients. I am skeptical about a major role for advisory opinions. I've always been against forcing the number of advisory opinions, finding ways of having greater recourse to them. Firstly, in my opinion, it downgrades the good result looked at generally of litigation outcomes. It becomes an alternative to that with the argument you should obey, but it's not compulsory in the same way as a litigation directive is. And there is just something artificial about it, in my view. I think the need for advisory opinions comes along in an absolutely natural way, but I can't see it as being harnessed to the general problem we're talking about. Then there's been the discussion of national courts and the role they play in developing, or it was rather contentiously put, making international law. Of course, the statute, we know, refers to courts and the decisions of courts, and it doesn't refer just to international courts. And almost definitionally, until fairly recently, immunity issues have arisen in national courts. A party seeks to bring a state to court and in a national jurisdiction, and the court claims immunity. And I would say that in interpreting and understanding both I'm just tempted to say common law, but general international law on immunity and the different statutory provisions that have grown up over the years, there's simply no doubt that the leading role has come from national courts. I don't think they are, quote, making international law in a general sense, but in that area in particular, their role is very, very important. There's a risk in this wide recourse as a strategy to a variety of courts, of blanketing those courts with a specific emergency problem or a crisis issue. As somebody boldly said yesterday in one of the panels, perhaps it was today, that the use of international law by the European Court of Justice is both infrequent and sometimes surprising. There have been some interesting international law findings there. The risk, I think, is in the human rights field. I've never been one greatly concerned about fragmentation. And that's another interesting thing to note, that 10 years ago, fragmentation was the big issue of the day, and the increasing availability of courts was said to be sure to give rise to that. And as those who know what I've said at the UN and what I've written, I have never regarded that as a major problem, and I think that has proved to be the case. But there is a serious issue so far as human rights are concerned. As Dapo has said, the feeling that legal norms are for the world at large is so important. And in the field of human rights, very particularly, I think we need to try to speak with one voice so that we move away from the idea that there's Jewish human rights and Islamic human rights and Asian human rights, European human rights. I used to tell my students that that is the language of states. It's not the language of victims. If you're a victim without fair trial or undergoing torture, you don't say that's fine because mine's a regional human right. It's not a global one. That is the language of states. So I just wanted to point out that there is a risk we run in that field.
Thank you. So let's take some questions from the audience. We've got the roving microphones. Please indicate if you have a question, and we will come to you in the front here.
Thank you very much. Antonis Zanakopoulos from the University of Oxford and the International Law Association. I have 4 questions and 16 comments. It is a genuine question. And I'm wondering, so Philippa, you started this asking everyone whether international law is equipped to sort of like respond to crisis. And I couldn't help wondering at that time, is international law actually supposed to respond to crisis, or is it rather something that is meant to absorb crisis, to act as a shock absorber in the system? And what I mean by that is, for example, pick a crisis, any crisis, and see how we deal with it. So, for example, we're dealing with, let's say, with the economic crisis, but then international law gives all sorts of tools that states can use to sort of like absorb the shock from that crisis through, loan conditionalities and so on, constructing bailouts, and there is no lack of creativity in how they've used it to deal with economic crises around the globe. Use of force, severe violations of human rights, things like that. There's all sorts of sanctions, wars on terror, what have you. There's all sorts of sanctions that states have resorted to, whether it is sort of like within the collective network framework of the United Nations, or individually, or sometimes in parallel, to sort of deal with that. So the tools for that are there, and we've seen no lack of creativity in the type of those sanctions, right? I mean, technically, even the creation of the STY and the STR are non-forcible measures of the Security Council under Article 41, so on Fox News, otherwise called sanctions. Look at the environmental crisis, right? We have the Paris Agreement to sort of kick the whole thing into the long grass. And the interesting thing is something that Dame Rosalyn said when referring to Syria, and she said how quickly we've forgotten this, right? So the new crisis comes along, the shocks from the last crisis have been absorbed, people may be drowning in the Mediterranean, and sort of like Syria may still be burning, but and before that Libya was burning, and before that all sorts of things. But we move on to the next crisis, and we think about how to respond to it, when in reality all we do is we're actually using international law to absorb it, to give states time to sort of formulate new policy, which will then ossify into new law. It is a genuine question. I'm not making it as a statement. I just want to see whether you think, or can it be both, a response and a shock absorber? Sorry, that was a very long question. in lieu of for
Indeed.
Thank you. I think what you're drawing out, and this certainly came out in a panel earlier today on customary international law, is the risk of normalization. So the normalization of crisis as our everyday state, constantly, as individuals in fight or flight mode, but as a system in an exceptional mode, invoking circumstances precluding wrongfulness, invoking derogations. Is that healthy or not? Over to our panel.
Well, I simply agree with what's been said in putting the question. Systems of law don't normally respond to problems. They sometimes will need adjusting, but if a lot of murders are happening in a year, you don't say there's something wrong with the law of murder. You look elsewhere. Yeah. So I agree that we are talking about absorbing and pointing ways forward rather than anything else.
Yeah. Well, yes, but again, you said something very important. It's not for the lawyers and the law to deal with all the problems. Yes, that absorption function is very important. To give you another example about the current peace and security crisis and the UN. The first veto in the Security Council triggered an immediate emergency, that's the name, special session in the General Assembly, who got 141 votes condemning the military action. So a reaction provoked by a certain flaw of the international system. But you do not know the other side of the mirror, which is, can we quantify how many conflicts were prevented by international law or by the existence of the system? You can't, because you're a lawyer like me. You'd have to gather a team of historians to look into these. I mean, did the international system and the UN and the Charter help the Cuba Missile Crisis escalating even further? We don't know, we're speculating. So yes, it's very true, but it's incomplete as an analysis that I don't think we lawyers are able to do alone.
Sarah?
So I was listening and I was wondering whether you thought it was a positive thing or a negative thing that international law was absorbing crises, because it could simply be normalizing crisis, but it could also be tempering and mediating crisis. So reducing the severity and length of crisis. And as Miguel says, very hard to know because we only know the situation we have. I'm a glass half full kind of person, so I like to believe that international law is serving that function, but I think that we also have to recognize that the tools international law gives us are also created by states, and they're created by states with competing and often contradictory interests, and they're implemented by states with often competing and contradictory interests, and therefore we may feel a frustration that we just don't have the tools that we need for a particular situation, going back to the first question. But in substantial part, that's because that's the way states made it, right? So that these institutions only can be so effective in different contexts.
Any closing comments? Sorry.
Yeah, I would say all of the above, really, in the sense that I think some areas of international law that are directed at crises are directed at encouraging or creating a mechanism which the aim of which is to solve the problem. So if you think now we think the peace and security mechanism not working so well, but if it was working well, the idea of the law is actually to create an institutional mechanism for dealing with threats to the peace, breach of the Peace Act of aggression. So the aim is to solve it. But then, of course, you have other rules of international law that are intended to apply in moments of crisis where the aim isn't to solve the problem, but actually maybe to mitigate the problem or maybe just to think about a different frame of relations during the crisis. So sticking with the peace and security example, if you think about the application of the law of armed conflict. So there's an armed conflict going on. This is a moment of crisis. But that branch of law isn't doing anything actually to solve that problem. It has a very different role. It's about trying to regulate as best as possible how we live in this moment of crisis. And then I guess you have other branches of international law which one can describe as a shock absorber, but they're sort of a bit more neutral. But in one sense, they're allowing states to respond without necessarily directing how they respond. So if you think about in the human rights sphere, so derogations, for example, it doesn't necessarily tell you how you should respond. You have limitations, with regard to how you derogate, or if you think about, say, in the trade context, the national security exception. So it comes in to give you flexibility without necessarily telling you actually how that flexibility should be directed. And maybe that's the shock absorber, where there's a bit more leeway that's given to the state that is responding because it's a moment of crisis, but you can't quite say that the law itself is trying to solve that problem of crisis.
Like the ICJ likes to say, by means of your own choosing.
By means of your own choosing, exactly.
Please come into compliance. We have time for one or two more questions. I'm looking at the app then. Oh, there is. There is one. Thank you.
Thank you, Craig Messenger, University of Bristol. Apologies, I was tentative to ask. It's a bit of a parochial question, the usual, about my area of interest. We've talked a bit about international tribunals, what might they do or might they not do, the consequences of litigation, what do you do when you have gaps in the law and you try and plug them. I think of the World Trade Organization, where we have quite a lot of rules, actually, and we have de facto compulsory jurisdiction and, in theory, two-tiered dispute settlement, the system that James Crawford famously referred to as the most successful interstate dispute settlement system ever, and in crisis. Are there any lessons to be learned from the WTO for the rest of international law and tribunals?
Maybe I can start. Maybe I can start with that because it does link to one of the things that I said earlier, that we've in the last sort of 30 years we have greatly strengthened dispute settlement in international law in many ways. So this big increase in the number of tribunals that we have, and this big increase in the number of cases before those tribunals. But what we haven't actually strengthened significantly is how the law actually develops and forms. In fact, probably by contrast, that has gone in decline. So in terms of lawmaking, at least treaty making, the situation is not as rosy as it was before. And my view of the WTO, and this is not to, this is not to give validity to the claims of certain states, but I think in the WTO there is that imbalance in the sense that dispute settlement is easy in the system, but changing the law is not so easy. And that creates certain incentives. It creates certain incentives where if you don't like the law as it is, then you're not so happy that you have a system that can easily enforce the law, but actually it's not so easy for you to change the law. And that's the lesson that I would draw, that I think we need to work not just on dispute settlement, we need to work also actually on how the law develops. Otherwise, dispute settlement ultimately becomes discredited because there'll be some actors who will have an interest in not wanting to move forward in that sphere.
But Dapo, the implication of what you're saying is that while there are now many more judicial pronouncements, and we have on one side the debate as to whether that is changing or developing the law, that nonetheless it's out of kilter with real developments, which I understand you to say are needed through multilateral treaty mechanisms. But that's simply not going to happen much anymore, is it?
True. I mean, so I do think that it is out of kilter and that can create some problems. I mean, it's interesting to think about where multilateral treaty making is happening and isn't happening. So I think we all sort of share this view that we're not seeing the big multilateral treaties, and that's a cause of some discomfort. But when the legal counsel was talking earlier today in the morning, I actually reminded myself that in the environmental sphere, we are seeing some. So the BBNJ, even the Paris Agreement is 4 years old?
The plastics.
5 years old, the plastics. Now, so I share your view. I think you're absolutely right that it's not happening in the way we saw it before. The question I have, and I don't have an answer, is why are we seeing it in some areas but not seeing it in other areas?
Because we probably don't need them in other areas. I mean, when there is a very urgent need of a multilateral treaty, it will happen. For instance, during the pandemic, at some point there was the discussion of a new treaty on pandemics. And I just asked my WHO colleagues, because I think there was mostly in Europe, I said, do we need another treaty? Or do we need to use properly the treaties we already have? Mm-hmm. So if the need is there and it's very urgent, something will happen, I think. And because, again, I think in the environmental field, it's so existential, things are happening.
Yeah.
Because member states realize that.
And no state can hide from the consequences.
And not as fast as we would like, but we see some action. We see that things are moving, that member states, maybe under the pressure of their citizens, are realizing how fundamental this is. Yeah. But again, we were in the golden age of multilateralism translated into treaties. We have about 600 multilateral treaties, or 987, I think, to be more precise, concluded under the auspices of the United Nations. That's a lot of treaties, right? At the field that we have not mentioned international trade law. It's super active lately. There were 2 or 3 new treaties concluded in the last 5 years, the Singapore Convention. So these are not mainstream. But yet, for instance, there's a very strong interest by the Global South in the development of international trade laws. Very high demand of training and so on. So I think if we don't have many more, it's because we don't really need them at this stage.
Yeah.
Or maybe it's that enough states don't agree that we need them.
That's more in the cyber discussion.
So I think we're coming to the close of our taking stock. And I had a last question for our panel, but I think they've actually answered it along the way. So I'm going to summarize your answers. So my last question was going to be, even if this is not an exceptional moment, it is a critical moment. So what does it require of us as international lawyers? How should we be investing our time and skills? And I think the answers that have emerged are that we should do what we can manage to do, that we should build connectivity, that we should try to find the workaround, unlock the potential of what we already have, including our existing institutions, and we should always try to keep international law sustainable in the broadest sense and universal. Please join me in thanking our panelists.